So we'll start with the first topic. So this is related to a recent judgment that pedestrians' rights are also the fundamental rights. Okay, so can you relate this right to any of the fundamental right? Article 21. So Article 21 is such a broad right, you can relate anything to Article 21. Other than that, 19, right to movement. Okay, so if you go in the footpaths, ಇಲ್ಲೇ ಚಂದ್ರ ಲೇಔಟ್ ಫುಟ್ಪಾತ್ಸ್ ಅಲ್ಲಿ ನೀವು ಹೋದ್ರೆ, ಓಕೆ, ಇಲ್ಲಿ ಕೆಳಗಡೆಯಿಂದ ಮೇಲ್ವರೆಗೆ ಫುಟ್ಪಾತ್ ಅಲ್ಲಿ ಹೋಗಕ್ಕಾಗತ್ತೆ ನಿಮಗೆ? ಇಲ್ಲ. ಏನೇನು ಇರ್ತವೆ ಅಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ? ಶಾಪ್ಸ್ ವಿಲ್ ಬಿ ದೇರ್, ದೆನ್ ಪಾರ್ಕಿಂಗ್ ಲಾಟ್ಸ್. Okay, so that is why recently state government want to clear all of these from these footpaths. Okay, so recently a 5-year kid, okay, he died in Karnataka. Okay, he was killed by a truck, okay, while he was walking. So that was the reason this came into light. So this pedestrian right is also a fundamental right. Okay, so you can, as I told you, you can relate it to Article 21. So Article 21 talks about right to life. So for new batch, polity has not yet happened, but for others they have already studied the polity. So Article 21 talks about right to life and liberty. Okay, so your safety in the pedestrian, in the footpath will also be part of this. You have the right to life and liberty. Okay, and then Article 19(1)(d), as I told you, right to movement, okay, will also be affected because of this. Okay, and Article 19(1)(a), (b) as well as (c), that is freedom of expression, assembly as well as the association. So why they are linking it to this is, so if somebody is walking, so that can impact their freedom of expression. Okay, assembly, if somebody are going in the footpath to assemble somewhere, and if something happened to them, then it violates this freedom of assembly and association also. Okay, and the lacuna is there is no central law that governs the pedestrian rights in India. Okay, so now in this judgment what the Supreme Court said is, the authorities, that is the urban local authorities, they have to provide and maintain a clearly marked footpath. Okay, so 3 days back, so people, they were breaking the constructions that are there on the footpath. So that is to make sure we have a cleared, marked footpath. Okay, so that was the reason. So, and also in this judgment they told that this is an enforceable public duty and not an optional service by the municipalities. So what do you mean by enforceable public duty? Legal backup. Okay, enforceable, that means what? You can move to the court. Okay, if somebody is violating, okay, if your right is getting violated, you can move to the court. And especially now the Supreme Court has linked it to the fundamental right. Okay, you can directly go to the Supreme Court under Article under Article 32. Very good, 32. What does Article 32 says? Right to constitutional remedies. Okay, you have the right for the constitutional remedies, not just the ordinary remedies, it is the constitutional remedy. See, fundamental rights from Article 12 to 35. The Constitution in Part 3 of the Constitution from Articles 12 to 35 mentioned these fundamental rights. Okay, and the most important thing is the right to enforce these above rights is itself given in the Constitution. That is also a fundamental right. If you give the rights, if you give the fundamental rights, and if you do not give this enforcement right itself, or right for a constitutional remedy, then there is no meaning to these rights, to these fundamental rights. Okay, so that is the reason Dr. B.R. Ambedkar told that this Article 32 is the heart and soul of Constitution. So now, since now it is the right to public footpath or safe public footpath has been linked to Article 21. So now this became a enforceable public duty. So that means what? The urban local bodies, municipalities should ensure that people get the safe footpath. Okay, that is the thing. And also they told that this right of pedestrians to use the footpaths, it should override the convenience of the motor vehicles. Okay, if somebody is walking on the footpath and if someone came with a vehicle on the same footpath, okay, they'll start fighting. Okay, I am going, why you are coming this side? ಕನ್ನಡದಲ್ಲಿ ಇನ್ನೂ ಚೆನ್ನಾಗಿ ಜಗಳ ಮಾಡ್ತಾರೆ ಅಲ್ಲ. Okay, so you are not supposed to take this as convenience of the motor vehicle should not be prioritized, should not override the use of the footpaths for walkers. See, we always see when we are crossing the road and if some vehicle is coming, what they will do? They will compete with us. First ನಾನು ಹೋಗ್ತೀನ ನೀನು ಬರ್ತೀಯ ನೋಡೋಣ ಅಂತ ಹೇಳಿ. Okay, so once I experienced this. So I was working in IT. So I was going in the morning to the office. So IT adu, it was a tech park. IT ಪಲ್ಲಿ ಇಲ್ಲೇ ವೈಟ್. Okay, so I was walking there. So I was about to cross. Okay, and a vehicle was coming with a speed. Okay. Okay, so vehicle was coming with a speed. So by seeing me, the driver stopped the car. Okay, he allowed me to walk or pass. Okay, so that is one kind of civic sense. Okay, that we have to cultivate, that we should give priority to the walkers. Okay, not to the vehicles. Okay, so but hanganta heli madhya road alli ello cross agokobedi, you should cross in the zebra section. Okay, not in the other areas. So now apart from this right of pedestrians, the Article 29, that is right to life, has been expanded, okay, by the Supreme Court, and it has included all of these under Article 21. Right to clean air and water, right to health, livelihood, shelter, right to privacy, and right to education. So based on the case to case basis, so when the several cases came up, so why not this pedestrian right was declared as part of fundamental right much before? Because now the situation has arisen, one case has come, and now the Supreme Court has declared that right of pedestrians is also the part of fundamental right under the Article 21. Okay, so here you can talk about that why law alone is not enough. As I told you, okay, see the law, okay, which is there in the books, but it is up to the government agencies, or you can say the bureaucrats, to implement this law. So in India we have so many good policies, but these are not being implemented properly. So we fail in the implementation. So that is the reason just making the law in book is not enough. Okay, it should come to the field. That means what? We have to implement it properly. Okay, so you can talk about a Street Vendors Act of 2014. A Street Vendors Act of 2014 was, the law was formed, and it led to the vending zones and vending committees. So vending zones is nothing but the, in footpaths. Somebody who will who will sell in the footpaths. Street vendors, okay, sorry, street vendors anta heltivi. So for the street vendors, this law actually tells that the street vendors should have a separate zone. They should not be there on the footpaths. There should be a separate zone for them to sell whatever they want. Okay, that is what is the vending zone. Okay, that is mentioned in this law, but in many of the states this is not being implemented. So that is why the law itself is not enough. Rather, it has to be implemented properly. Okay, and one success example is there is a decline in public smoking because of the regular awareness campaigns. Okay, so advertisementally Mukesh will come. Okay, if you go to film, Mukesh will come. So, and also on the this gutka cover also there is awareness picture. Okay, cancer one picture iruttade. So this is how by regular awareness the public smoking is in a decline. Okay, so similarly they are telling that pedestrian safety also needs the public awareness and culture. Okay, this is very important, the culture to respect the walkers. Okay, so this is the need of the hour. Okay, so one second. So here you can link it to ethics. Okay, ethics question ಏನಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ law versus morality. Okay, so UPSC has asked this question many a times about the law and morality. What is law, what is morality, how both are different, one, and how the law enforces morality. So can someone tell me what is morality? What is morality? What is ethics? What is ethics? Ethics is nothing but a set of guidelines, right? Ethics is nothing but it is the set of guidelines that defines what is good or in say bad, and it will help you to take the decisions, okay, based on the situation. So this is ethics, and this ethics is externally given. Okay, externally given means society will give you some ethics. Okay, the constitution will give you some ethics, the law will give you some ethics. This is externally given, whereas morality is the one that is, morality comes from within oneself, maybe based on the experience, okay, how they have been brought up since their childhood. So this will define our morality. So here a question can be asked, how the law can influence the morality. Let's say few hundred years back, okay, sati was practiced. Okay, sati was practiced, but through law this was prohibited. Okay, but now do we consider it as moral? That age or in that society it was considered to be moral. Okay, when the husband dies, the wife also should sacrifice. It was considered to be moral. Okay, but now it is not considered as moral. Okay, so and in recent cases also, child marriage was also considered to be ethical in that society. Okay, so but now through the awareness and education, now we believe that child marriage is unethical or immoral. So this is how the law will also influence the ethics and morality. So that is how the law can enforce the ethics on the one hand, and in reverse the ethics, or you can say the morality will also influence the law. Can you give me one example where morality can influence the law? ನಾಚಿಕಂತಾರೆ ಅವರು, ಬಾ ನೋಡಲ್ದೆ ಅವರೆಲ್ಲ ಮುಖ ಮುಚ್ಕೊಂತಾರೆ, ನಾಳೆ ಮತ್ತೆ TV 9 ಬಂದಿತ್ತು ಅಂತ. Okay, so tell me one example where morality can influence the law. I told you what is morality, right? So tell me how one individual's moral values can influence the law. Can you remember any kind of one incidents or situation where one person's moral values became law, or it influenced to make a law? Not taking bribe. Very good. Okay. Then do you remember Raja Ram Mohan Rai? Modern history. Raja Ram Mohan Rai. So he fought against what? ಎಲ್ಲ ಎವಾಪರೇಟ್ ಆಗೋಗಿದೆ ಸರ್. ಇನ್ನೊಂದು ವರ್ಷ ಮತ್ತೆ ರಿಪೀಟ್ ಮಾಡಿದ್ರು ಅದೇ ಅಲ್ಲ. Okay, so tell me, Raja Ram Mohan Rai, he fought against what? Sati. See, he fought against sati. So this was his moral belief that sati is inhuman. Right. So okay, so he fought against this sati, which influenced the British to come up with a law to prohibit the sati. So that is how individuals' moral values can influence, or you can say it can be base for the law. Okay, so in both the ways the UPSC has asked the question how the law can bring the ethics or morality, how the ethics can influence the law in both the ways. Okay, so here, so need for balanced implementation, that means what? So when you are removing the street vendors, okay, for the safety of people, or you can say to protect the right of the walkers, okay, you will have to balance. For these vendors also you need a place. That means what? You have to rehabilitate them. Okay, to safe place to carry on their own business and also ensure safety for the walkers. So here I try to link it to the case studies in ethics. So in UPSC, so many of the case studies, they have asked the question, okay, related to this, that is rehabilitation of farmers or tribals, okay, versus development or protection of someone else's rights. So in ethics case study also, this can be a good example. Okay, we need to balance both, not just removing the vendors and poor workers from the public spaces. So suddenly if you evict now, it can destroy their livelihoods also. So that is the reason to protect one's fundamental rights. Okay, so we need to balance both the ways. So there is a regulated vending areas can be brought, so where the street vendors can do their business there and also ensure safety for the pedestrians in both the ways. Okay, so now the second topic is related to the regulation of foreign contribution to NGOs. What are NGOs? Non-governmental organizations. Okay, so these are not the governmental organization, non-governmental organization. Can you give me an example for NGO? Can you give me some example for NGO? There are so many NGOs. Okay, regarding child rights and you. Huh? ABVP. Huh. Okay, other than that. So we have some of the NGOs related to women rights, tribal rights, okay, disabled rights, transgender rights. Okay, so many NGOs are there. So these NGOs, they get the fundings from foreign, okay, maybe from foreign organizations, okay, or foreign governments also. But why should we regulate this foreign contribution to NGOs? NGOs will get the money and resources for their own work and responsibility. Why should the government regulate this foreign contribution? ಕೆಲಸ ಇಲ್ಲ ಸರ್ ಮಾಡಕ್ಕಂತೀರಾ? ಮೋರ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಸಿಗುತ್ತೆ ಅಂತನಾ? Oh. One thing. Then before that, ಅದಕ್ಕಿಂತ ಮುಂಚೆ it is mainly to protect the national security, okay, and unity and integrity of India. Okay, of course NGOs, some of the NGOs are really doing good, the charity works, they are fulfilling their social responsibility, but it should not impact the national security, unity and integrity of India. They should not work against India. Okay, that is the reason there is a regulation for the foreign contribution to the NGOs. So now why it was in the news is recently a FCRA amendment bill of 2026 was brought. So this is an amendment bill. Basically this FCRA is nothing but Foreign Contribution and Regulation Act. Okay, a FCRA law was brought in the year 2010 and now this is being amended. Okay, in 2026. So that is why it was there in the news. So in this 2010 law, FCRA law, this regulated the receipt and use of the foreign donations, be it individuals or associations, okay, and NGOs. Okay, and this is being administered under the Ministry of Home Affairs. Okay, the foreign contribution to the NGOs or associations is regulated by the Home Ministry. Okay, so these foreign funds which are received via this FCRA registration, that means the NGOs or the associations who want to receive the foreign contribution, they should be registered under this law, that is FCRA. You are supposed to register under this FCRA, or prior permission for a specified donor and project, okay, or a prior permission to get the funding is also required. And the restrictions are these funds cannot affect India's sovereignty, as I told you, security, communal harmony, or you can say the friendly foreign relations also. So, and according to the law, the NGO or association who want to receive the funding, they have to maintain the prescribed bank accounts, okay, in SBI branch in New Delhi. Okay, in a SBI branch, State Bank of India, in New Delhi itself. Okay, and there should be regular audit of the statements also. So when it comes to NGOs, we have so many NGOs related to the social activities like health, okay, and like eradication of poverty. Okay, we have NGOs that can help in the child welfare, some in transgender, some in women. Okay, some of them we have the NGOs under economic activities like this: agriculture, livelihood generation, skill development. We have educational and cultural, even religious activities NGOs are also there. So these organizations that are registered under FCRA, they have to disclose their geographical scope, okay, websites, social media accounts, digital platforms, okay, and annual publications. All of these should be in the public domain. Okay, so because you are receiving the foreign contribution, okay, you need to maintain the transparency. Okay, so now under this amendment, the complaints and penalties have also been increased. So the one who is violating these provisions will attract the penalties up to rupees 1 lakh. Okay, and even these foreign funded assets, or you can say the NGOs that will create assets using the foreign funds, the assets like schools, hospitals, okay, vehicles, these all will come under the state control. Okay, after the suspension or cancellation, if some NGOs have been suspended, then their property will come under the government control. Okay, that is the thing. Okay, so now these actually the NGOs, they are supplementing the state capacity. The state or the government itself cannot bring health for all. They cannot eradicate poverty for all. Okay, they themselves cannot fulfill child rights or women rights. The NGOs are in fact helping. Okay, so that is why the law that we bring to regulate these NGOs, it should not be too restrictive. It should not be too restrictive that you discourage these NGOs to fulfill their social responsibility. On the other hand, the law should not be too much flexible that you give way for these NGOs to use the fund, okay, to use the fund for some illegal purpose. So this is why the balancing act is very much relevant. Okay, so here they are relevant constitutional values in 19, 25, 26 and 300A. What are these? What is Article 19? Article 19, freedom. Okay, right to freedom for 6 rights. Okay, what are these 6 rights? Freedom of speech and expression, then freedom of movement, freedom to form assembly, okay, freedom of movement, freedom of what? Freedom to form association, okay, freedom to form association, okay, and freedom to follow one's profession. Okay, so these are the 6 rights which will come under this Article 19. So what is Article 25? 25 is related to religious rights. Okay, freedom of religion related to what? Freedom to profess, okay, and practice and propagate one's religion. 26 is related to freedom to manage one's religious affairs. So why we are linking to these articles is Article 19, that is freedom to form associations. This can be impacted due to this law. 25, some of the organizations, that is religious organizations, and their rights can be violated. Even 26 also. But what is this 300A? What is Article 300A? Yes. So Article 300 is nothing but it talks about the right to property under Article 300A. See, initially when the Constitution was formed, at that time right to property, yes, right to property was also the part of fundamental right under Article 31 and even Article 19. Okay, so later through which Amendment Act it was removed? Later through 44th. Okay, so newcomers don't worry. So when we read the polity, that time you will read it. Okay, so through the 44th Constitutional Amendment Act, this right to property under fundamental right was removed, and it was made as a constitutional right or a legal right under Article 300A. So what is the difference between this fundamental right and constitutional right then? Enforced not only Supreme Court, even High Courts also. That means what? You have the constitutional remedies under Article 32 if a fundamental right is violated. Whereas any other right which is there in the Constitution other than fundamental right, you will have a legal remedy. Legal remedy means what? You can go to the other courts, or you can say the High Courts, but not under the Article 32 of the Constitution. Okay, that means what? The courts cannot issue writs, which they usually issue on the violation of fundamental right. You have the other legal rights and not the remedy for the constitutional. So, sorry, it is not a remedy related to the fundamental rights. So that is the thing, 300A. So once UPSC has asked the question on this Article 300A, they have asked what is the status of right to property in India. What is the status of right to property presently in India? The status, okay. So first statement was asked. Okay, what is the status of right to property in India? Okay, so the first one is, it is a constitutional right which is available to citizens only. Second, it is a constitutional right which is available to any person. Third one, it is a fundamental right which is available to all the citizens. Fourth one, it is neither a fundamental right nor a constitutional right. Huh? Option B na? Odidira? Huh? So anybody else? Option A. Then anybody else? What is the answer? See, the property can be held by an individual, okay, by some organization, by some company, by NGO, okay, even a foreign nationals can also hold the property. If you can see some of the companies, foreign owned companies are there in India. So this article 300A, in article it will tell you that the right to property, so it will tell you that any person, the right to property under article 300A is available to any person. Any person can hold, dispose the property. Any person will have the right to hold or dispose the property. So this term, any person, that means what? It is not just to the citizens, okay, rather it is available to the foreigners who are holding property in India, and also the legal companies, associations, NGOs. Okay, any person is correct. Okay, so can you tell me the fundamental rights that are available only to citizens? 19. Then 22. Then 31. 31 removed anta ಹೇಳಿದಿವಲ್ಲ ಇವಾಗ just. See, just think which are the articles that can be available only for citizens. See, article 15, right against discrimination in case of only religion, race, caste, sex and place of birth. So this is available to only citizens. 15. 16 related to the public employment. So the one who can enter to public employment is only citizen. 16. 19. Not 18. 18 of 2, that is okay. 19 freedom. Then 29 and 30. So these are the fundamental rights that are available to only citizens. All other fundamental rights are available for both citizens as well as non-citizens. So since this right to property is not under fundamental right now, it is under 300A, is a constitutional right. Okay, or it is also called as a legal right. So can you tell me what is the difference between a legal right and constitutional right? Legal right. So legal right is a broader term. Okay, so legal, anything, any right that is given legally, that we call it as a legal right. So within which will come the constitutional right, the one which is given by the constitution, and the non-constitutional rights, these are given by the parliament through the law. Okay, so that is the. So now in Karnataka also SIR is going on. Okay, so next one is related to the Uniform Civil Code. Assam has brought Uniform Civil Code Bill. Okay, so what is this Uniform Civil Code is? Okay, so tell me what is Uniform Civil Code is? Uniform. Okay, uniform means common. Okay, so uniform. So throughout India, there should be one single civil code. So now what is civil code? Civil code is nothing but it is a common rules related to the civil matters like marriage, divorce, adoption of children, property rights. So these are the civil code, and there should be a uniform civil code throughout India irrespective of one's religion. Now if you take the marriage, property, and divorce, we have the laws dictated by the religions. We have Muslim personal law. So there is a Hindu law. So when it comes to civilian matters, so the different religions have their own laws. So now the thing is it has to be replaced by the Uniform Civil Code is the debate. So this Uniform Civil Code is given in the directive principles of state policy, which is given in part 4 of the Constitution under Article 44. So any of the provision that is given in the directive principles of state policy, it acts as only a directive to the government which is not enforceable. The difference between a fundamental right and a DPSP is a fundamental right is enforceable in the courts, whereas a DPSP is not enforceable. And our constitution makes us place this Uniform Civil Code under Article 44 of DPSP. The question is, why? Why did they place it in DPSP? And by placing it in DPSP, they made it as not enforceable in the courts. Right? So why it was placed in DPSP? 1. Is a uniform civil code throughout India essential? No. Why? Why a uniform civil code is not required? Is it required or not required? We have a diverse country. Then sensitive areas. What are the sensitive areas? Northeastern tribal areas. You can tell that. Then see, we have the diversity, we have different religions, we have the tribal communities, We have different culture and customs based on the community. But don't you think all these practices that can impact the rights, all these practices that can impact the rights of individual should not be practiced? The inheritance rights, okay, in some religion polygamy is allowed, okay, in some it is not, okay, some religions have their own property inheritance rules, okay, some have different kind of property inheritance rules. In some, woman will get the property rights, in some it is not. So don't you think this uniform civil code is essential in India? Yes? Okay, now suppose if we bring the uniform civil code in India, what can happen? What are the negative impacts? I told the positive. Now tell me what are the negative impacts? Conflicts, religious conflicts, then that may affect. Okay. Okay, then see, uniformity, it does not mean that, okay, you bring a single law that can fit the entire population. Of course, we have to protect the fundamental rights. Okay, of course, we have to protect the fundamental rights, but on the other hand, we have to also protect the culture and belief. Okay, so we have seen both the positives as well as negatives. Now, what should be the conclusion then? Or what should be the way forward? Sorry?
Depending on states.
You leave it to the states. Okay, then? Then what you can bring? Consider
major aspects.
Major aspects. ಯಾವುದು major aspect ಅಂದ್ರೆ? Okay, we need to build consensus among various groups in India. There is a need of proper discussion and deliberation among the religious groups and other groups. Okay, and also parliamentary discussion is essential. And then what solution you can bring? Okay, instead of one single law by the parliament, okay, you can leave it to the states. Okay, they can bring their own law based on their own culture. Okay, they can consider their own diversity of population. So this is just I am telling the analysis for mains. So now this uniform civil code was brought by the Assam is excluding the tribal areas. Why should tribal areas be excluded? They come under the 6th schedule, that is okay. but these tribals will have their own customary practices. What is a customary practice? What is a customary practice? Customary practice is nothing but the practice that is being followed since ages. Okay, that is, we call it as a customary rites. So these tribals in the 6th schedule will have their own customary practices. So by bringing a uniform civil law can impact these practices. When they impact the customary practice of the tribals will lose trust on the government. They will think that the government is infringing in their own jurisdiction. So they will lose the trust. So again, this will create a gap between the tribals and the government. They feel that we are being forced to follow these laws. So that is the reason the tribal areas are excluded from this law, Uniform Civil Code. So here it is defined, Uniform Civil Code is nothing but the common set of personal laws for the citizens in these matters of marriage, divorce, inheritance, adoption and succession should be followed. A common set of personal laws. So as I told you, it is given in the Article 44 of Directive Principles of the State Policy, where the constitutional makers, they left it to the state to bring the uniform civil code when the country reaches to a stage. Okay, when it reaches to a stage where the uniform civil code can be accepted in the country. That is why it was placed in this directive principles of the state policy, which is non-enforceable. So now by passing this bill, Assam has become the 3rd state in India to bring this uniform civil code after Uttarakhand and Gujarat. There is one more state in India which is following the uniform civil code. Yes, Goa. So they are, it was under which rule? Portuguese. Okay, since then they are following the uniform civil code. Okay, it was the Goa that was following the uniform civil code, and now recently Uttarakhand and Gujarat have brought the law, and now recently Assam has also brought this law. So the main focus of this bill is to prohibit the polygamy and establish a gender equal inheritance rights. Okay, that is the main aim. So they given what are the key features of this bill is ban on polygamy. Okay, what is polygamy? Marrying monogamy. See, gamy is nothing but monogamy. Okay, unity of two people. So in marriage, a male and female. Monogamy means you are marrying to a single person. Okay, at one point of time. Polygamy means you are marrying to multiple people at a single point of time. That is polygamy. So it bans polygamy with the imprisonment of up to 7 years, and mandatory registration of marriage and divorce should happen within 60 days. Okay, live-in relationship, mandatory registration of the live-in relations within 1 month. Okay, see again here I will talk about the morality versus law. In present society of India, is live-in relation accepted? Accepted, that is what. So, though it is being practiced, it is being accepted by the present youths. Okay, in present youths, there is divided opinion, right? So here, how many of you are for the live-in relation and how many of you are against the live-in relation? Huh? No relationship is best. Okay, so the live-in relation, so this mandates, the give rise to the mandatory registration of the live-in relation within 1 month, and it sets legal age of marriage up for 21 years for the men and 18 years for the woman. And in case of inheritance, equal property for sons, daughters and spouses. Okay, exclusion of scheduled tribes, as I told you. The 6 scheduled areas, the scheduled tribe areas have been excluded from this law. So when the Uttarakhand government has brought the bill, so it was very much into the news. So registering the live-in relations, will it be a threat to them? Will it be a threat to the couple or not? Live-in relation, if they have to register within 1 month, when they have to register, will it be threat to those couples?
Yes.
Yes. But then what is the purpose of this registration? What is the purpose of registration? So don't you think it is affecting their privacy? Okay, it is affecting their privacy. Then the social morality can be enforced on these couples. Social morality. What is social morality? It is not individual morality, rather it is a social morality. That is whatever the society believes to be right. So that will be enforced on these couples. Then it can also be danger to their life. Honor killings. But then why the government has brought this in the law that they should register within 1 month? Can you think of some reasons why should the government bring such a provision that the live-in couples should register?
What about child?
That is one important thing. If they bear child, what will happen to the rights of this child? Maybe the property, inheritance, or you can say the legal recognition of the parents. Child right is one thing. Then
If the violence happened to women,
very good, domestic violence. Then then ಹುಡುಗ ದುಬೈ ಓಡೋಗ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಸರ್? Right. If there is breakup in between, if there is a breakup, what will happen? See, in case of legal when there is marriage, okay, if there is divorce, okay, then the husband will have to compensate for the woman, or if the fault is woman, then she will have to compensate. But here there is a gap in case of live-in, right? So that is why the government wants to be registered. So mainly to protect woman's right. Okay, so this is the intention of the government. However, there is a positive impact and there is a negative impact also. So now suppose say there is a question in society or even in the governance asking the live-in relationship has to be registered, okay, critically analyze. So this is how we will bring both the positive and negative. So now tell me what can be the way forward. What can be the way forward? Police protection should be given, sir. Huh? Identity should not be disclosed. Good. Identity should not be disclosed. Then there is a need of law that can regulate this live-in relationship. The law to protect women's rights or sometimes men's right also. Children's rights. Okay, inheritance of property. So we need a detailed law with respect to this. Okay, fine. So the next one is related to the preventive detention. Misuse of preventive detention powers by the state. Okay, so recently in Uttar Pradesh, 2005 people were detained, and the Allahabad High Court, okay, has told that so there is a violation of the law because they have been detained, okay, for the wrong reasons. So now, what is this preventive detention? First of all, what is detention? What is detention? Detain, you are detaining some person, okay, you are arresting or imprisoning, okay, that is called as the detention. But what is this preventive detention? No, not like that. Preventive detention, you are detaining a person to prevent him from committing some crime. Okay, so detention is you are detaining a person, you are arresting a person after committing a crime. Preventive detention is before committing the crime. You are going to prevent him or her from committing the crime. That is preventive detention. So Constitution under Article 20 will give the protection against the detention or arrest, whereas Article 22 will talk about this preventive detention. Okay, so here this preventive detention will allow the state to detain a person before committing the crime, but that should be based on the public order, okay, morality and health. So the state cannot detain a person for any kind of reason, okay, it should be impacting the public order morality. If you see in some of the Ganesha festivals, Ganesha festival iddaga, they usually detain some of the communal leaders, that is to prevent the communal violence in the area. So it should be based on these, public order, morality and health. And also this Article 22 will provide safeguard for arbitrary detention or arbitrary preventive detention. Okay, so how? Because when you detain a person, the person will have the right to be informed of the grounds, okay, why they are being detained. That has to be communicated to that person. Okay, and also there are legal provisions under the National Security Act and BNSS. What is BNSS? Bharatiya Nyaya Suraksha Sanhita, which replaced CRPC. IPC replaced BNS, Bharatiya Nyaya Sanhita. Okay, so this preventive detention orders will be issued by the executive magistrates. Who are executive magistrates? Executive magistrates. First of all, what is a magistrate? Who is a district magistrate? Judge. See, a district commissioner or district collector is also called as what? DM, district magistrate. Why? Head of the executive antalla. So because as a district collector or commissioner, they have some magistrate functions also. Tax disputes. Okay, whenever there is a revenue dispute or tax dispute, the DC, okay, will act as a district magistrate and can issue the magistrate orders. Court ing issue madattalla, so in the same way they can issue the orders. So that is why the district commissioner will also have some of the magistrate powers. Okay, so here again this can be issued by the magistrate. Where is this? Executive magistrate. So the executives who are holding the magisterial functions are called as executive magistrates. So they are empowered to issue the preventive detention orders under this BNSS. Okay, so and also preventive detention should follow, or you can say it should not be arbitrary, it should protect the right to life and liberty. The ground on which you are detaining a person, that should be prescribed by the law. Okay, and you have to follow the procedure which is there in the law. Okay, not the arbitrary arrest. Now the problem lies, okay, not in this preventive detention law. The problem lies in the use of this preventive detention. Sometimes the government will detain people based on arbitrary reasons. Arbitrary reasons. Okay, without any substantive criminal charge. So here in this case, what happened was a physically challenged Dalit advocate was arrested for a petty neighborhood dispute. Okay, so even for some small reasons also it was being used. Specific abuses, okay, that are unspecified also. And the authorities impose the unaffordable bonds. Okay, unaffordable bonds, they have to do some security deposits. Okay, if you imprison a poor person and if you quote a high security bond, then the person will not be able to submit it and they will remain in the custody itself. Okay, and now the court directed the executive magistrate, they have to justify the decisions for this preventive detention, and there should be compensation for unlawful detention, and this compensation will be recovered from that concerned magistrate or police officer. Okay, that is the court direction. So the thing is, actually the preventive detention, it exists to ensure public order, okay, to ensure public safety, but it should not be used to suppress the dissent or to resolve petty disputes or cases. Dissent means what? Should not suppress the opposition, anyone. It is not just opposition party. If somebody is talking against the government, that is also called as the dissent. Okay, so the preventive detention should be used only to protect the public order and safety, and it should not suppress the dissent or to resolve petty disputes. So genuine implementation is needed for administrative accountability and judicial vigilance. Okay, so you cannot maintain the public order by sacrificing the liberty, right? So both should be balanced. On the one hand, public order, on the other hand is the liberty. So we have to balance both. Okay, so now we will move to the Supreme Court. So recently an ordinance was passed to increase the number of judges in the Supreme Court. What is ordinance? What is ordinance? What is a law? In Supreme Court vidra? Huh? Okay, leave it. So tell me, what is a law and what is an ordinance? What is a law and what is ordinance? Law is justice. Ordinance is injustice. Huh?
Ordinance is temporary, sir.
Very good. Nodi ee just ಬಂದವರು ಆನ್ಸರ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Ordinance is a temporary law. Okay, that is declared by either president at the center or governor at the state. Okay, yav time alli, in which time? Not emergency, when the assembly is not in session, state assembly or in the parliament, either Lok Sabha or Raj Sabha, if they are not in session, okay, at that time ordinance route can be used, because any bill to become a law, it needs to be supported in Lok Sabha and Raj Sabha. Okay, and then finally it will go to the president. Now when either of them are not in session, then an ordinance route can be used. Okay, so now to increase the strength of the Supreme Court, an ordinance has been passed, okay, by the president. So it increased the Supreme Court judges' strength from 34 to 38. Initially in the Constitution, it was mentioned that the Supreme Court strength, judges' strength will be 1 plus 7, CJI and 7 other judges. So now 38, that means 1 plus 37. 37 judges and 1 Chief Justice. So now what is the need to increase the number of judges in Supreme Court? ಓದ್ಕೊಂಬಂದ್ರ ಇವಾಗ ಜಸ್ಟ್ I think she was absent for 1 hour to read this magazine and come to class. Okay, it has been in the news, right? Okay, so to reduce the pendency of the cases which are there in the Supreme Court. Okay, so Supreme Court is having is a constitutional role. Okay, it is the highest constitutional court of India. Is there any court greater than Supreme Court? No, supreme. That is why it is called as supreme. Okay, so it is a constitutional role. Constitutional role means what? It can interpret the constitution. It can protect the constitution. Okay, so the key functions are it will decide major constitutional questions. Major constitutional questions, okay, like the provisions of the constitution. If there is some case, which can be related to the provisions of the constitution or interpretation of the constitution, then it is the Supreme Court. Okay, for example, basic structure. Okay, for the first one we saw pedestrian rights as a fundamental right. That is again an interpretation by the Supreme Court. Okay, and it is an appellate court. So, constitutional question of center-state disputes, interpretation of the laws and issues of national importance. So, that is a key function. Appellate court. Appellate court andre eno? Appellate court. You can go by the appeal. Okay, illinda ಮೇಲೆ ಹೋಗುತ್ತೆ ವಯಸ್ಸಾಗಿ ಸತ್ತೋಗಿರಬೇಕು ಅವನು. Okay, this is appellate court. Lower court, some 5 years. Then go to the district court, 10 years. Go to the high court, 20 years. Supreme Court ಮುಟ್ಟಿದ ತಕ್ಷಣ already. Okay, so that is a appellate court. You go to the Supreme Court by the way of appeal mechanism. In case of fundamental right, directly. Okay, so not through the appeals. Article 136. So under this Article 136, okay, this grants a special leave petition. Now we should understand what is this special leave petition. Article 136, special leave petition. Suppose say any one of you go to the Supreme Court. Okay, you go to the Supreme Court with a case and the Supreme Court will give a verdict. But you are not happy with this verdict. What you will do? You will re-appeal. Okay, you will re-appeal. So now this re-appeal will go to the another judge of another bench of the Supreme Court, and there also they will give the same verdict which you are not happy. So first you go to the Supreme Court, the verdict was given, you are not happy, re-appealed, again the judgment was same, you are again not happy. So in any such cases, if you want to again appeal to the same Supreme Court, then a special leave petition has to be filed. Special, okay? So this can be allowed by the Supreme Court only on the special grounds. If there is some heinous crimes, okay? So it is up to the Supreme Court to decide which case I have to allow for the investigation once again. So this is a special leave petition under Article 136. So why we are talking is there is pendency of cases. Yes, why there is pendency of cases means this Article 136 is being used oftenly. Special leave petition is being often used for the cases that involve grave injustice. Leave, okay, not to the cases which doesn't involve even the grave injustice, or can say the substantial questions of law. So that is why the case load is increasing on the Supreme Court. So the Supreme Court, which has to be actually a constitutional court which can protect the constitution, interpret the constitution, deal with the cases which actually has the question of the constitutional provision. It has to be this constitutional court, but of late it has become a court of appeal. Court of appeal. Challenging star Darshan Supreme Court hogade. Normal Manushara Supreme Court hogade. So it has become a court of appeal. Okay, rather than being a constitutional court. So that is why the pendency of the cases are more in the Supreme Court. Okay, so now this increase in the judges strength is a limited solution, but what we should do is the inflow of cases to the Supreme Court, that has to be reduced. So any kind of the smaller cases has to be dealt by this subordinate courts itself. Okay, district court and then the high court, they themselves has to resolve it, whereas the Supreme Court, it should deal with the constitutional cases. Say suppose in India, if there is some other court higher than the Supreme Court, what will happen? Everybody will go, right? When there is an option, obviously they will go. If there is open to international court, they will go to there also. So if you give an opportunity, obviously people will appeal to the higher courts. So the solution is not just increasing the judges' strength, but we have to reduce the number of cases that can reach to the Supreme Court. So now we have the two other concepts like additional judge and ad hoc judge. Okay, we have to understand what is this additional judge and ad hoc judge. See, additional judge to the Supreme Court and High Court, ad hoc judge to the Supreme Court and High Court. Additional judge, that means you are appointing a person to act as a judge for a temporary time, okay, for up to 2 years. So here it is the president who can appoint an additional judge. Okay, it is the president who can appoint an additional judge either to the Supreme Court or High Court, and that person who has to be appointed as additional judge should be qualified to become a judge of either Supreme Court or High Court. If appointing to the Supreme Court, then the person should be qualified to become judge of Supreme Court. If to be appointed to the High Court, should be qualified to become the judge of the High Court. Okay, so now the president can appoint a additional judge to either the Supreme Court or the High Court for a temporary period, and such a judge should be qualified one. And such a person can be either from a district court or can be an advocate also. Now, ad hoc judge. With respect to the ad hoc judge, ad hoc, the term itself will tell you this is a temporary appointment. But the difference is, in ad hoc judge, you are going to bring the retired judges. Here that is not the case. In case of additional judges, in ad hoc judges, you are going to bring the retired judges who are already retired. So there are more cases, so they can be also appointed as ad hoc judges. But here it is the Chief Justice, with the prior permission of the President, can ask some retired judge to act as a ad hoc judge either to the Supreme Court or High Court. So in case of Supreme Court, Chief Justice of India with President's permission will request a retired judge. In case of High Court, the Chief Justice of that High Court will request the retired judge with the prior permission of the President, okay, for as a ad hoc judge. So these two provisions you should remember. In case of additional judge, it's the President who can appoint an additional judge to the High Court. Okay, it is the President who can appoint additional judge to the High Court. So here one thing you remember, in case of additional judge, okay, a President can appoint someone as additional judge to the High Court, not to the Supreme Court. But in case of Supreme Court, it is always the Chief Justice of India, but with previous permission of the President. Okay, can ask someone to act as the ad hoc judge. So now this increasing the strength of the judges was criticized because You are using the ordinance route. ಶ್ವೇತ ತಿನ್ನಮ್ಮ, ಏನಾಗಲ್ಲ. ಯಾಕಷ್ಟು ಊಟ ಮಾಡಲಿಲ್ಲ? ಊಟ ಮಾಡಲಿಲ್ಲ? ಯಾಕೆ ಅಷ್ಟು ಕಷ್ಟಪಟ್ಟು ಬರೋದು? ಊಟ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ ಆರಾಮ್ಸೆ. ಹೆಂಗೂ ಕ್ಲಾಸ್, ರೆಕಾರ್ಡೆಡ್ ಕ್ಲಾಸ್ ಸಿಗ್ತಾ ಇತ್ತು. ಇರಲಿ. Okay, so this ordinance route is being criticized because you are bypassing the parliament. Okay, if you are bypassing the parliament, that means what? You are bypassing the democracy, because parliament is nothing but member of parliaments who are elected by the people of the country. So indirectly you are bypassing the people's representatives. Okay, and this ordinance making power is for the urgent situations when the parliament or the state assembly is not in session. And it is also said that need to regulate special leave petitions. As I told you, the special leave petitions are even given for the petty crimes. And also more judges can lead to, it can lead to what? More judges will also lead to the subjectivity or the different interpretations by different judges. Okay, and also other than that, government litigation. Government is also one of the largest litigant in India. Okay, government is itself involved in so many of the cases. And a national litigation policy is required, okay, to prevent the repetitive, weak and avoidable government litigations also. Okay, so this suggestion also you can write. And the one more, okay, 1 second. Okay. Okay, so Delhi Gymkhana Club, Land Lease and Government Land Administration. What is this Gymkhana Club? Gymkhana ಅಂದ ತಕ್ಷಣ ಜಿಮ್ ಮಾಡೋ ಪ್ಲೇಸ್ ಅಂತ ಅನ್ಕೋಬೇಡಿ. It is not that. Delhi Gymkhana Club. So it is a club that was founded in the year 1913 during the British time itself. So this was a social club, okay, that included the British officials. But now later, after the independence, now this is a club of senior bureaucrats, military officers and senior professionals. So it is a club of these people. So now what is the news is, now the Ministry of Housing and Urban Affairs, okay, they have told this Delhi Gymkhana Club to vacate 27.3 acres premises, okay, citing the ground of national security and public interest ground. That means the ministry wants to use this property for defense. So that means what? They are, okay, acquiring the property. They are telling this club to vacate this premises so that this land should be used for the government purpose, okay, for the public purpose. And this land is being administered by the Land and Development Office under the Union Ministry of Housing and Urban Affairs. Now this ministry has issued the order to this club, Delhi Gymkhana Club. So here you need to understand two concepts. One is freehold conversion, okay, in another is leasehold land. Okay, so leasehold land means the government, okay, is giving on lease the property and it remains the owner okay, and gets limited rights subject to the lease condition. The government is giving on lease the property, that is a leasehold land. Although government is the owner, they are giving to someone as for the lease. Freehold conversion. So here freehold conversion means in some of the cases what will happen is this public purpose land, okay, it can be transferred from government control to the private also. That is called as the freehold conversion. So based on the lease clause, the government can reclaim the possession of such land for the public purpose, national security purpose. Okay, so this is related to the Delhi Gymkhana. The next is formalization of election resettlement in Great Nicobar. Okay, tribal self-governance development. So have you heard of the Great Nicobar project that was there in the news, the Great Nicobar project? So for this, okay, for this, and also to update the electoral rolls in this Andaman and Nicobar, the Andaman Nicobar government has proposed a draft electoral rules for these Nicobarese village and tribal councils, and also resettlement and rehabilitation of the people who will be affected by this Great Nicobar mega infrastructure project. Okay, so that is why it was in the news. So the Nicobaris are the tribals, Andamanis. Who are the tribals who are there in the Andaman and Nicobar Island? Andamanis, Nicobaris. So based on the tribals name only, the island has been named as Andaman and Nicobar. Okay, Andamanis, Nicobaris, Onges. Okay, so these are some of the tribes in this Andaman and Nicobar. So Nicobar is how the tribal governance is. Okay, so they are a scheduled tribes. Who are scheduled tribes? What is the meaning of a scheduled tribe? Scheduled caste, scheduled tribe. What is the meaning of this? Scheduled tribe is nothing but the tribes who are listed in the schedule of the constitution. Okay, they are called as the scheduled tribes. And since the tribals, okay, tribals rule or the village administration structure is based on the customary practices. So there will be a village captain in each of the village, and then there will be a tribal council. Okay, tribal council where the people will elect this tribal council, and the leadership will be based on the consensus. That means all the people will select a leader. Okay, consensus based leadership, and there will be council elections, and there is also statutory recognition to these tribal councils under this Tribal Councils Regulation 2009. So now with this, what is this? Okay, formalization of election and resettlement. So under this, what the government has done is they have proposed a draft electoral reforms in this tribal region. So the draft rules propose the formal elections for the village and tribal councils. So they also introduce a constituency delimitation. What is the meaning? What is the meaning of constituency delimitation? You are going to fix the boundaries of the constituencies. Okay, constituency delimitation. Okay, electoral rolls. Electoral is nothing but Okay, voters list, electoral roll, nomination procedure, voting counting. So all of these, okay, has been notified under this. And also it has proposed the reservation of seats and leadership position for the women in this tribal land. So now, because of this proposed policy, the leadership selection in the tribal area, as we saw that it was a consensus based leadership selection. Now this consensus based can move to the ballot based selection. Sorry, it is election. From selection to election. Okay, ballot based election. And the customary authority may become more legally standardized and bureaucratic. What was considered to be a customary practice to elect the leaders, now that will be legalized, legally standardized, and it will become more of bureaucratic. Okay, that is the thing. And so this election will be, it will be like a mainstream election, competitive political process. Okay, nominees, okay, election campaigns, all of these will also be happening in this tribal land. So these reforms, by these we can ensure transparency, accountability and standardized leadership selection. Okay, people's representation can be ensured. Okay, so where you can bring the democracy in the tribal land. But there are concerns. Concerns are, it can weaken the customary institutions like the local panchayats. It can also improve, lead to politicization and factionalism, division among the tribals itself. Okay, and it can erode the indigenous autonomy, the freedom that is there to the tribals, and it can erode their cultural practices, the traditional practices also. And this, as I told you, the Great Nicobar project, this policy includes the resettlement and rehabilitation census. So the tribals who are being affected by this Great Nicobar project, they need to be resettled and rehabilitated. So that census is also going on in this. Okay, so this will identify the affected families, okay, verifies their land and livelihood records also, and determines the compensation under this Land Acquisition and Rehabilitation Act of 2030. And this covers the families who are affected by the trunk infrastructure, including the trunk road. What is this? Trunk road andre? Trunk road is nothing but it is the main road where there is heavy traffic. So usually national highways, so these are called as trunk road. Okay. So these families, the affected ones, should submit 24 categories of identity, they are telling. Okay, of proof of residence ownership for the proper resettlement and rehabilitation. And it has raised concerns about the displacement of Shompen. Shompen is also a tribal community, which is nothing but it is a PVTG. PVTG means particularly vulnerable tribal groups. So particularly vulnerable tribal groups they are more vulnerable. Okay, they are more vulnerable. That means they have very less population, very low population compared to even other tribes. They are called as the particularly vulnerable tribal groups. Okay, right to be forgotten is completed last time. Anti-defection law, stability, legislative freedom, and the merger debate. What is anti-defection? Okay, switching the political party. Okay, so this law was not there initially. Okay, it was not there. The political process in democracy, the election will go on, and the party that gets majority will form the government. Okay, this was going on in India, but there came a situation, okay, in 1980s where these elected MPs and MLAs, they started to switch the parties frequently. So it was famously called as Aya Ram Gaya Ram. Okay, it's a Hindi term, Aya Ram Gaya Ram. Aya Ram Gaya Ram anta hedre Aya Ram Gaya Ram, banda hoda. They elected as MPs and they again switched the party. When they switched the party, again they had to go for elections. Okay, so that was the Aya Ram and Gaya Ram. So now what the parliament did was, it came up with a constitutional amendment. Okay, 62nd constitutional amendment, and it introduced this 52nd. 52nd. Right. 52nd amendment. It introduced 10th schedule of the Constitution, okay, to reduce the defection. So under this 10th schedule, what are the provisions? Under the 10th schedule, what is the provision? 75? 75 marks ತಗೊಂಡಿರ್ಬೇಕಾ? See, if the elected representatives, okay, if an individual elected member, if they are switching the party, if they are elected from one party but they want to switch other party, then they will lose the seat. That means what? They have to go for election again. Okay. Then second, a nominated member will have the 6 months period to join a political party. Post that, if they join, they will lose the seat. Okay. Third one, a independent member. Independent member means the one who is elected independently, not from a political party. If they join some political party, they will lose the seat. That means they should again go for the election. And apart from this, there was a provision that 1/3 of the representatives, okay, if 1/3 of the representative, they switch the party, they will not lose the seat. That was there, but this was again changed. Okay, this was again amended, and it was mentioned that 2/3 of the members should shift to the other party. Then they will not lose the seats. So this is entirely about the anti-defection. Okay, as I told you, original provision, the constitution dealt with the legislative disqualification under these Article 102 and 191, but this did not involve the defection cases. 52nd amendment was brought that inserted the 10th schedule. Okay, Aya Ram Gaya Ram. So reserves the government. What was the reason? To ensure the stability of the government, and also to ensure the people's choice is upheld. Okay, if somebody is elected from some party, the people might have elected him because of the ideology of the party. If now they suddenly switch the party, it will impact the choice of the people. Okay, and here one more thing is, you should keep it in mind of voluntarily leaving a party. Okay, they will be disqualified for voluntarily leaving a party or defying the party whip. without permission. So party whip andre yaru? For defying party whip, see in assembly, okay, in assembly, in either in state assembly or even in the parliament, Lok Sabha and Raj Sabha, each party will have their own whip. This whip is like a PT teacher in our school. Okay, they will stand with a stick. If you are not obeying the party's advice, okay, then they will be considered, it will be considered as a voluntary leaving the party. So and it depends upon the party also. Okay, so these will be considered. And disqualification for voluntary leaving. So this voluntary switching the party or voluntary defection, there is a broad definition. Even the Supreme Court has interpreted that this voluntarily, defecting the party, it also means that during election, if a member is campaigning, if a member from one party is campaigning for the other party, then also it is considered to be the defection. And who is the deciding authority in case of defection? It is the speaker in case of Lok Sabha and state assembly, and chairman in case of Raj Sabha and state legislative council. Okay, they will be the deciding authority with respect to the defection cases, and their decision is subject to judicial review. So this was the verdict of Supreme Court in a case called as Kyoto Holohan case. Lide nodi, Kyoto Holohan versus Jish ಏನೋ ಒಂದಿದೆ. So it was in this case, Supreme Court told that the decision of the speaker or the chairman is subject to the judicial review. So here there is a debate related to split and merger, as I told you. Split, 1/3 of the members, if they are switching the party, it was considered to be a defection. Initially it was recognized, but later it was amended. Okay, that is through the 91st Amendment Act. This was removed, and only 2/3 of the members, 2/3 members switching the party was accepted. So the split of 1/3 was objected, but merger of 2/3 members was, it was accepted. And now a question comes related to the legislature party versus political. Okay, now you are telling that 2/3 members, okay, 2/3 of the members should defect from the party or they should merge with other party. But there is a difference between a legislature party and a political party. Okay, say suppose Aam Aadmi Party. Recently, the members of AAP, they defected to BJP. Okay, so this Aam Aadmi Party members who are there in the Lok Sabha, okay, who are elected to the Lok Sabha, are called as legislative party. These only people will not, represent this entire Aam Aadmi Party. Okay, Aam Aadmi Party is a big party through which these people are elected, so they will become legislative party. So now the 10th schedule is talking about 2/3 merger, right? 2/3 of the members should merge with other party. So these 2/3 members are they legislature party or political party? You are telling 2/3 members should merge with other party. Is this a legislature party or the 2/3 of political party you are talking about? That is the legal question which is unaddressed. That is why recently, in case of Aam Aadmi Party members, it was in the news. So they perfectly formed 2/3 of the legislature party. 2/3 of the members of the legislature party, they merged with the BJP. Should we consider it as Aam Aadmi Party merging with BJP? Because the political party is a larger party, it's a larger body. So here the party leaders, okay, party leaders and members, they also should obey, right? Okay, so that is the legal question that is still unaddressed. Okay, so the originally, as I told, original framework protected the split and merger. 1/3 was also accepted, but later it was removed, as I told you. So here for the merger, what they started to do, collective resignations, okay, re-elections, all of this started to happen. So legislature party versus the political party. So legislature party will consist of elected representatives within the house. Within a house, how many elected representatives from a particular party is called as the legislature party, whereas political party is a wider organization, okay, with constitution, leadership, ideology, workers, symbols and voters. So this is the difference between a political party and legislative party. So in the 10th schedule, they have just mentioned merger of 2/3 of members of one party with the other, they are told, but they are not defined whether it is a legislature party or a political party in that. Okay, so that is the question to be addressed. Okay, so the reform options, as I told you, restricting the whip. So whip is a party whip. Okay, they need to be restricted only for these major, like confidence motions, no confidence motions. Okay, and this disqualification decision, which is now being taken by who? Who is the judge for this disqualification cases in case of anti-defection? Just now I told speaker in case of Lok Sabha and State Assembly, chairman in case of Rajya Sabha and State Legislative Council. So this disqualification decision should be by an independent constitutional authority. Okay, and within a fixed time limit. So that is the solution that you can suggest. Okay, so now let's have a debate related to women's representation in India's Supreme Court. So what do you think? Should women's reservation also should be given in judiciary?
Yes.
Why? Huh? Reservation ಬೇಡ, ಎಲಿಜಿಬಲ್ ಆಗಿದ್ರೆ ಓಕೆ. See, why should the woman should be given the reservation in case of judiciary? Or you can tell why should woman given reservation in case of women's reservation in Lok Sabha, 33% reservation. What is the need? Empowerment. Okay, then that is why. What is the reason that women's representation should be there? Equality. Then gender sensitive law. Okay, the law making with respect to the woman, gender sensitive law. Okay, children protection. If a woman is judge and if there is some case which is related to these, okay, she can take the good decision. So that is the reason that the woman has been given the reservation in the representation also. So till today in India, okay, so far in the Supreme Court, there is no woman Chief Justice of India. Okay, till today, even after 75 years of independence, Supreme Court has not seen a woman Chief Justice of India. Okay, and even the direct appointment from the bar. Bar means don't think about bar and restaurant alla. This bar is Bar Council. Okay, lawyers and advocates. So again, why the representation of women matters? Because the issues which are affecting the whole society, including the women and marginalized communities, will be there. That is why the women's representation also should be there. Okay, so here there are barriers for the women related to the career growth. Okay, and judicial appointments, direct appointments is also rare, and some of the countries they have brought the reforms in the case of judiciary, where they have given, some countries have given 33% reservation, some have given 50% of the reservation also. Okay, see here, Belgium has gender quota. At least 1/3 of the representation should be given to the woman. That is in constitutional court. Constitutional court means what? It should be the apex court of the country. And South Africa has also diversity of racial, gender in the case of top courts. Similarly, Canada, Germany, South Africa and Belgium, they are moving towards this 50% quota for the woman representation. So by giving women the reservation, the judiciary can be more inclusive, legitimate as well as socially representative. That is the point. And apart from the woman, when you say the woman, it also includes the woman from backward communities like SCs, STs and the OBC community also. So here they suggest constitutional amendment to these articles 124, 217 to improve the gender diversity in the case of Supreme Court and High Court appointments. That is basically to give the reservation to women, particularly in judiciary. Okay, so the next news is related to the global crisis needs strong institution and not just the citizen sacrifice. So this is related to Prime Minister's statement. So Prime Minister told, in the case of recent Iran versus US conflict, when the gas price was spiking, the Prime Minister, he told that, okay, so the people should use the resources judiciously, effectively. Okay, stop, okay, unnecessary travels. Okay, stop using the, using bike. Buying foreign goods, gold. So he told all this. So this is related to that. See, global crisis need a strong institutions. Okay, not just citizen sacrifice. And also he was telling, stop buying foreign goods. Okay, buy the Make in India products. So if we buy Make in India products, are they costly or cheaper? Cheaper. A hand woven saree is much more costlier than a machine made one. Okay, so that is the reason that we need a stronger institutions, not just citizens sacrifice. Okay, energy or supply chain disruption was there. So we need a stronger institutions. So in this era of globalization, okay, every country is interdependent and they are interlinked with one another. Okay, so what happens in one country can impact the other country also. So because for example COVID, so which started in China, it spread to the entire globe. So the globalization has not only interconnected the people, goods and services, but it has also interconnected the problems of the world. Climate change is one such problem. So what we need is the responsible consumption has to happen, social solidarity. Okay, and also the government responsibility to bring the institutions like health, education and infrastructure, economic stability. Okay, so all of these are required. Okay, not just a citizen sacrifice. So this is the main crux of this news. So when we have the weaker institutions, weaker health systems, weak emergency response, okay, public transport, urban planning, so we are asking the citizens to sacrifice. Okay, so double burden of malnutrition. So ಏನಿದೆ double burden? Double burden of malnutrition ಅಂದ್ರೆ ಏನು? Over nutrition. So lack of nutrition ಅಲ್ಲಿ there are two types. One is undernutrition. Malnutrition ಅಲ್ಲಿ two types. Undernutrition ಒಂದು, ಇನ್ನೊಂದು overnutrition. Okay, overnutrition ಅಂದ್ರೆ excessive, like obesity. Okay, excessive fat. So ಅದನ್ನ overnutrition ಅಂತ ಹೇಳ್ತೀವಿ. So another is undernutrition. So it is a lack of the nutrients. So India is suffering with both. Okay, one hand we have the undernutrition, low weight born babies, okay, low height. So these are all the undernutrition. On the other hand we have the obese people. So that is a overnutrition. So how many of you fall under first category? Undernutrition. Overnutrition. No, all of you are normal. There is no overnutrition. Okay, so in case of this undernutrition, we have three terms: wasting, stunting and underweight. Okay, wasting, stunting, underweight. Wasting anta helidre low weight for your height. Okay, so there is a set criteria that people of this much height should have this much of weight. So if you have the low weight per height for your height, then it is called, we call it as a wasting. Stunting anta helidre low height for the age. Okay, with respect to the age, your height will be measured, and if you have low height for a prescribed age, we call it as stunting. And then is underweight. Underweight, that means below normal weight. Low weight for the age prescribed. So these are the terms we will often see in the news: wasting, stunting and underweight. So you should know the definition of these terms. So overnutrition, as I told you, it includes obesity, diet related risks. So why now in India this overnutrition is increasing? Overnutrition ಯಾಕೆ ಆಗ್ತಾ ಇದೆ? ಒಬೆಸಿಟಿ ಯಾಕೆ ಬರ್ತಾ ಇದೆ? ಜಂಕ್ ಫುಡ್, ಫಾಸ್ಟ್ ಪ್ರೊಸೆಸ್ಡ್ ಫುಡ್ಸ್, okay, bakery food, okay, and along with that the work nature. The work nature has become more of what? Sedentary. Sedentary andre, okay, you sit on the chair, office kind of work. So it's a sedentary kind of work. So because of these there is increase in NCDs, non-communicable diseases, okay, like blood pressure, sugar, okay, cancer. So like this, the non-communicable diseases are also increasing. So I think I told you about National Family Health Survey in the previous class. So National Family Health Survey. So this NFHS 6, okay, indicates there is a improved child nutrition in India compared to the earlier surveys, but there is uneven progress and regional variations. Okay, there is a regional variation and uneven progress. That means what? The regions, okay, that fall under the poverty, okay, the undeveloped regions, okay, will usually face this problem of undernutrition. Okay, whereas the regions that are too high developed, urban areas, they usually face the burden of overnutrition. So if you take a poor family, what they will have in the breakfast? Idli, vada, dosa. You are telling about a middle class family. If you go to a lower class family, ganji, ragi mudde, ragi amblit or ragi malt, okay, usually that is what they will have. Okay, but the thing is, they will not have the diversity of food. Okay, although it is good for the health, the diversity will not be there. Similarly, if you go to a rich family or a urban family, what they will have? Sandwich, burger, pizza, and the Chinese kind of food, pasta. Okay, so this will lead to the overnutrition, obesity. So this is what is a poor diet quality. Okay, and because of ultra processed foods, sugary drinks and low physical activity, okay, all this is leading to the burden of malnutrition. Okay, so the next one is related to the National Sports Tribunal has been established under the National Sports Governance Act of 2025. So this Sports Tribunal, okay, which is under the Ministry of Youth Affairs and under this ministry, okay, this will come. So the National Sports Tribunal is a statutory body under this Act of National Sports Governance Act. So I have told you, I think, what is a statutory body? The body that is established through the law, that is called a statutory body. So it is created under this National Sports Governance Act of 2005. So what is the role of National Sports Tribunal? First of all, what is a tribunal? What is a tribunal? It's like a court. It can't take judgments. Then see, you will have to understand what is a tribunal. So a tribunal is okay. A tribunal means it will be usually in a expertise area, or tax based tribunal, national green tribunal regarding the environmental protection. So such a kind of expertise body, and it is a quasi judicial. It is not purely judicial, it is not purely executive, so it stands in between. So we call it as the quasi judicial body. So this is a bit flexible compared to the normal courts, and they will have the functions of both executives plus judiciary also. Okay, so now this National Sports tribunal, the role is it will hear and adjudicate the disputes arising in the field of the sports governance. Okay, it is mainly related to the sports governance. Sports governance means mainly selection of candidates, okay, for the team selection. Okay, if there is any violation of the rules, if there is any act of corruption in sports selection, okay, if a player is involved in some illegal acts. So to hear all of these, we have a dedicated tribunal now called as the National Sports Tribunal. Okay, headquarters is in New Delhi. And the condition that the members of the tribunal should have the knowledge and experience in the sports, public administration as well as the law. Okay, and they will provide a specialized, faster and institutional dispute resolution. See, as I told you, if all the cases are going to the courts, then it will lead to the pendency of the cases. Okay, suppose say some dispute related to the cricket, and the judge who is sitting on that doesn't have the knowledge of cricket. Okay, so that expertise is required in the case of the dispute resolution. So where the tribunals will come into the picture. So there can be faster, specialized and institutional dispute resolution. So as I told you, the disputes may involve the selection of the players, governance of sports bodies like we have BCCI in India. Okay, and then administrative decisions and compliance with the statutory rules. In case of all these issues and disputes, these tribunals can adjudicate the cases. So mainly it will lead to the formalization of the sports administration in India. Okay, initially this was unregulated, now it will lead to the regulation and formalization of the sports administration. So the nodal ministry, I told you, Ministry of Youth Affairs and Sports. Okay, and this law, that is Sports Governance Act, this will regulate the sports governance, improves the transparency in sports governance, institutional accountability can be established. Okay, and also the dispute resolution can be ensured. The next one is national health accounts and high out-of-pocket health expenditure in India. National health accounts. What is national health accounts? National health accounts is nothing but it is the estimation of the health expenditure flow in India across government, households, insurance as well as private providers. Idana national health accounts anta heltivi. See, national means the entire nation. Health accounts, health means health related. Accounts means it is basically measurement of the expenditure. Okay, health account. Okay, so how the health expenditure flows in India across all of these is the national health account. What is out of pocket health expenditure? Expenditure from one's pocket. Okay, from one's own income, how much they are spending on the health care. That is out of pocket health expenditure. In some of the cases, government will also provide the health insurance. Okay, for example, Ayushman Bharat gives the health insurance to the BPL card holders up to 5 lakh. Okay, but still there is out of pocket expenditure, high out of pocket expenditure in India. So here this national health accounts is saying that nearly half of the current health expenditure is by the out of pocket expenditure. So this is a rising concern. And presently, how much the government is investing or its expenditure on health is near to 1.43% of our GDP. Okay, but this is much below the 2.5 GDP percent target of this national health policy. Okay, and we are yet to realize universal health care. What is universal health care? What is universal health care? Universal health care, that means health care should be accessible. Okay, it should be affordable for all the people in this country. So we are yet to realize the universal health care in India. So out of pocket expenditure, I told you, it is a daily spending by the households from their own pocket for treatment diagnostic hospitals. That is we called as a out of pocket expenditure. So although the government schemes like Pradhan Mantri Jan Arogya Yojana, or can say the Ayushman Bharat, aims to reduce the health expenditure, but the insurance coverage is limited. That is up to 5 lakh per family per year. Okay, and that too it covers only the secondary and tertiary care. Okay, Pradhan Mantri Jan Arogya Yojana. Again, low spending on preventive care. So we are focusing on diagnosis and palliative care. Okay, that means after the disease, we try to cure it, curative care. But we are not focusing on the preventive care. Okay, prevention of the disease. That is the concern. Okay, so the next one is related to the first amendment, first constitutional amendment and its implication for the democracy and civil liberties. So we will see first what is this first constitutional amendment. Okay, so what is the context for this first constitutional amendment? We have to understand. So what is the context is, so after adopting our constitution, okay, so what happened is the courts protected Article 19(1)(a), that is freedom of speech and expression. Okay, Article 14, that is right to equality and property rights, Article 31. So court was protecting these and they were immune from the parliament's power. So there the government felt that these courts are blocking, okay, its steps for social and economic welfare of the people. Okay, for example, the Article 31, right to property, this restricted the government to abolish Jamindari system. Okay, so that is why the government felt it is blocking its steps to bring social and economic reforms. And later, the First Amendment Act of 1951 was passed within 18 months of the Constitution, and this First Amendment created the 9th schedule. Okay, so I will tell you what is this 9th schedule and what are the other issues. With respect to Article 19, that is freedom of speech and expression, what happened is Supreme Court protected these newspapers, okay, from the government censorship. Okay, government is not supposed to censor these newspapers because they have the freedom of speech and expression. This is one case. Okay, case 1. And the next case is, okay, this is a Champakam Dorai Rajan case. Champakam Dorai Rajan, 1951. So what happened is, in the then Madras, there was reservation to the higher education based on the community, based on the caste. So this was declared to be unconstitutional. Okay, by the then Supreme Court declared it to be the unconstitutional. You are not supposed to give the reservation based on the caste and community. That communal reservation should not be there. Okay, so now consider this is the case 2. And then the next one is Bihar Land Reforms Act of 1950. So in Bihar, what happened is, to ensure land for all the people, they brought reforms in the land, distribution of the land. Okay, so this is the third case. Okay, so now what happened is, Supreme Court protected this, that is, these newspapers should not be censored and there should not be communal based reservation, and also they obstructed this Land Reforms Act because it is affecting Article 31, right to property. So this led for the then government, or you can say the parliament, has brought the constitutional amendments. Okay, so that was the first amendment act that was passed by the then parliament. So in this first amendment act, what they did, in this first amendment act, they brought this Article 31A, 31B and 9th schedule. Okay, so parliament brought this Article 31A, 31B as well as the 9th schedule to the constitution. So what happened is, so this brought changes to the freedom of speech. Okay, so they included these clauses, that is public order, national security, incitement and foreign relations, to restrict the freedom of speech and expression. Okay, and the reservation for social education backward classes, that is SC, ST, this was also added through this first Constitutional Amendment Act. Because in Champakam Dorai Rajan case, Supreme Court told that you are not supposed to give the reservation based on the caste. So they changed it to social and educationally backward classes, that is SCs and STs. And it also protected the land reform laws, Bihar Land Reform Act. This was protected by placing the law under the 9th schedule. So now, what is this 9th schedule? This 9th schedule is a schedule in which if a law is placed, if a law of the state or a center, if such a law is placed in this 9th schedule, then it should not be questioned, in courts. Okay, if a law is placed in 9th schedule, that means it will protect that law from the judicial scrutiny, or it will get immunity from the judicial review. So that is 9th schedule. Okay, so now, so this first amendment, why it was in news is, now it forms the 75 years for this constitutional amendment. Okay, in the 1951 it was passed, 2026 it is a 75 years of completion of this first amendment. So that is why it was in the news. So now when this 9th schedule has protected the laws from the judicial review. So now after this, what happened? So what happened is, these laws that were placed in the 9th schedule. Okay, so this was a constitutional amendment. They told the laws in the 9th schedule cannot be questioned in the court. But later what happened is, judiciary introduced the basic structure doctrine. In which case? Basic structure doctrine was introduced in which case? Yes sir, Bommai. But this doctrine was introduced by Supreme Court in which case? Very good. Kesavananda Bharati. Can you recollect Kesavananda? Kesavananda Bharati case of 1973, KB case of 1973. In this, Supreme Court gave this doctrine of the basic structure. So after this, what happened? The judiciary told that the laws that are placed in the 9th schedule before this Kesavananda Bharati case can be protected from the judicial review, but the laws that are placed after Kesavananda Bharati case of 1973, such laws will not have this immunity. They can be questioned in the court. So now the status is, this is the present status. The laws placed in 9th schedule before Kesavananda Bharati is not subject to question, but post that they are subject to be questioned in the judiciary. Okay, so that is related to the first amendment. Okay. So this is completion of the polity and governance. Okay, so next week we will cover the remaining topics.